Swayam Prabha. Digital India. Educated India.
Here in this session, how we will go, this is a broad outline, and we have, I guess, 30 minutes. So I will try to cover the things in that 30 minutes. So we will check about the India status, how exactly design registration is look into by that Indian citizens as well as foreign citizens. Considering India as a market, then we will see key features of Design Act, and already Sir has shared with us so many case studies. So we can easily relate that key features easily. So that legal point of view, how exactly the examiner look into while examining the application, that will be much very, we can say, easier with the case studies, whatever Sir has shared with us. I will share one case study so that we can just go into a little deeper about the commercialization aspect of industrial design, considering that industrial design, and then some few examples and obviously some questions to ponder when we are looking into the intellectual property. Now we are focusing on design, and we will check whether only design will help us to get wealth out of the investment, whatever we are doing. And this investment is not only we are talking about it's an intellectual property. So I'm talking about that intellectual investment, whatever we are doing, along with obviously the involvement of a monetary aspect during that project development, or when that product goes from that initial stage into the lab to the market. When we are talking about intellectual property, there are 8 types of IPs, and I will not go into details of any other IP because we have to just focus on industrial design. And a little bit aspect of patent, we will just look into whenever it is required, because whenever we are talking about industrial design, for what we are doing the industrial design, whenever engineer develops a product, we want that product to be marketed. And for marketing, I guess the look, the feel, how exactly you feel with that particular product when you see with your naked eyes, that is more appealing. And that aesthetic look, which is appreciated by naked eyes, is the subject matter for industrial design. So product design and industrial design are 2 different aspects. Product design, I will say that it is a more work of engineer or a technologist or a scientist, depending on that product and in which domain it is. And the industrial design is an aspect of designers, and they will look into the customer approach, how exactly customer will feel, how customer can be attracted and towards that particular product. And I can give you a classic example that whenever we go into the mall, this is the situation that many times we go with a list maybe of 10 products we have to buy, and we end up with buying some 20 products, maybe 15 products. Okay, why this happens? Because effective shelf management and this industrial design makes you tempted to buy that particular product, although it is not required. And how they are doing it? Whenever you are going towards a billing counter, what happens? You see the very different products with a lot of offers and very good designs. And many times because of that designs, because of that particular attractive nature, that aesthetic feel which attracts you, and you buy that product, maybe you may not be required that product. And whenever you come back to home, then you realize that, oh, I may not have required that product, but I have bought that product. So what is that exactly? That nice shape of a bottle, nice shape of a soap, nice jewelry design, nice packaging, all these things are attracting you. And then they have that industrial design will look into gender, look into the age, look into that ergonomics factors, and All these particular factors, sir has just shared with us how exactly they have looked into all and created that product. So functionality is aspect of a product design, design, and engineers are taking care of that. And in point of view of intellectual property, patent will take care of that. And design aspect is a job of designers, and they will look into how exactly that product will look when it will go into the market. Okay, now I'll just put few names and then you just think about what exactly comes in front of you. If I say Maruti, BMW, Mercedes-Benz, Hyundai, Toyota, maybe that car is going in front of you and you have that specific like impression considering design about that particular car. That's that particular color, that particular feel, and that is one of the important, I can say, specification when we are deciding to buy that particular car. Anyway, car is doing the task, the function is like mobility, travel, but why we choose a particular car and why all cars are not same? Because every person have a different taste, and based on that different different liking, the person is going to like buy that particular product from the market. You go into the shop, you have to buy the fan, and fan, the function is okay. It is giving you that cooling effect, and every fan will do that. But you have a specific like expectation, and you buy a specific particular fan from a specific company. Why this happen? Because many times that experience, that aesthetic look is like you think about how exactly it will look into your living room, how exactly you will, that color combinations, all these aspects you are taking into consideration. Now, statutory, if you see, there is a very good arrangement that these are the different acts you can just check out. That in that you can just check. Considering India, Designs Act 2000 is dedicated for this particular protection of designs, and design protection is for 10 years and renewable for next 5 years. So once we buy or once you have that registered design, total life of the design is 15. We have to understand that most of the intellectual properties, I'm saying most of the intellectual properties out of this 8, because some like few exceptions are there which are perpetual in nature. Obviously, you have to do the renewal. So design, when we are talking about total life of design, once we register in India, it is a 15 years. At first, whenever you are registering it, it is for 10 years. Obviously, you have to go for renewal procedure. If you miss that, your design will come into the public domain. So renewal is mandatory if you want next 5 years registration, where that life actually, right? Now, this trademark or patent, they have a different life, but I can just give you idea. Patent will give, patent is like granted when you are giving the, doing the application, life is 20 years. And trademark is one example, which is a perpetual in nature. So you can just see Philips, Siemens, more than 100 years, this particular, we can say, trademark is the, why they are doing the, that renewal every 10th year. That renewal is mandatory. If we miss that renewal, your trademark will go into the public domain. Now, next is like I'm showing you one map, and here it shows mithai, which is a particular to different states of India. We will come back to this in the last, and I want to know that from you whether design registration is possible with this particular aspect, that is a mithai. Now, when we are talking about a design, can it become an asset? I'm just sharing with you example. It is little old data, but that time also you can just check out that 95% or 92% or 88% of intangible, that if you see the market capitalization, intangible assets are taking. Means if you take an organization, intangible assets and tangible assets are two assets. Previously, before 1980, tangible assets were very important, that infrastructure and then the facilities which are there, the manufacturing unit, all this like tangible property was having important. But after 1980, shift is there and intangible assets like this patent, trademark, copyright, industrial design, trade secret, protection of plant varieties, farmers' right, geographical indication, semiconductor integrated circuit layout design, all this along with goodwills, obviously, all these are taking a chunk, and this is like a 95% of company asset or organization assets that are intangible assets. So we have to appreciate that shift, and we definitely have to focus and work on intangible assets so that we can create wealth out of them. Now, when we talk about industrial design, obviously different kind of packages. Packaging is important. I have just given you example of a mall where wherever you are going, we just get attracted towards that nice packaging, nice color combination, and we buy products. Then this is one example I have shared about that bicycle, and that specific specially abled people can use this, and so nicely it is particularly designed. So it serves the purpose, but obviously it is giving you the pleasure of having that particular bicycle. You are owning it, and obviously your task or your function for which you are buying that is done. And industrial design will give you that particular, we can say, the aesthetic aspect, and you are like happy to own that particular. Here are the different kind of, if you see the fashion industry, obviously it is dominated by industrial design. And even obviously all the market, wherever the market, the products are there, design is playing a very, I can say, indispensable role, because that is one thing helps you, or that is one thing, considering the seller, that helps seller to attract the customer. And obviously consumers or customers are attractive because they have a specific taste for them. Now, this, why design protection? Obviously, it is an exclusive right. Now, if you do not do the protection for industrial design, the chances are that competitors will like take that product into market. I would like to share a case here. I can take name of the company actually, Crompton Threads. Crompton Threads, if you see, Crompton Threads is a company which is in India. Every time, like CGPDTM office, our patent office, patent industrial design trademark registry, this office gives awards to the successful design creators. And Crompton Threads is a continuous, for many years, Crompton Threads was a leader, and they used to get that prize for their industrial design. Their main industrial design team is in Mumbai, and they are working on their products. So their motor pumps, their fans, all that electric appliances, design team there is working, and they are like giving the products into that as required, as per requirement of the consumer. Now, the example I want to share is like that they have designed one fan, and for that fan, they forgot or they have neglected the importance of industrial design, and they have not done the design registration for that particular fan. What happened? Whenever they have launched that product into the market, immediately, obviously, as there was no protection, their competitors, they have copied that particular design. And obviously, what is the effect of that? The fourth point, reduction in market share for the product. Without registration, as the registration was not done, everybody copied that. And obviously what happened, that 100% share, that exclusive share, probably they would have, if they have done the registration, they have lost that. And all competitors and other local vendors, they came up with that particular design for their fan as a product, and they lose that particular market share. So that is the person, the inventor shared that was a big loss for a Crompton and Threads, considering that particular. So your decision making before bringing that product into the market, IP management plays a very, very important. Sir has already that shared with us that the two important IPs they have there as a IIT Bombay, they have taken into consideration as a patent and design. But I would like to mention that along with that, for example, bottle he had shared, or for example, sunrise, he has coined that term. So probably trademark registration would also help to have a like holistic, we can say, that IP management. So trademark, patent, industrial design, and then the obviously trade secret is always there. And then copyright comes, but that we will not go into the details of that now. That is also playing the important role when about the IP management and any product whenever we take, all this IP come into the picture. What happens if you don't do the design registration? Obviously, you don't have any legal means, just Crompton Greaves case you can take. They don't have option, but everybody copied that. They have to, you don't have option as competitors are more, so you cannot have that upper hand to, and you have to sell your product in a lower price actually. Right? So it is harmful to both actually, firm's reputation also and a product also. Your risk return on investment will be obviously with these IPs, and we are talking about a design. When we do that, obviously it is a very good tool, very good IP when we are talking about the marketing to attract the consumer. So return of investment can be increased along with functional aspect, aesthetic aspect. You are merging, and that will give an advantage. So 10 years at least, if you will not renew it, but if you renew it, next 5 years, so total 15 years is the life of that design. Okay. And obviously it is a stray help in the brand building, because you just check out that when you talk about brand is a function of market. Actually, I will keep legal aspect and marketing aspect separately. Marketing is like brand is coming under marketing management, and a legal aspect is like industrial design. So when we are talking about that brand building, we can say that design as a legal, we can say the aspect. When you do that, if somebody copies that, you have a statutory provision and you can take action on that. You can license it, you can sell it now. Sir has shared that, okay, we have taken a patent in 4 countries. Probably there is a possibility that they can go for a design registration or design patent, because in India we say industrial design, but in US there is a design patent concept is there. So if you take that particular protection in different countries, you can license, you can hand over that franchisee, you can give that franchisee for your product, and they can take care of that. How you can do that effectively? Because you have IP in hand and you have protected it. Without that, probably you cannot do this particular activity of selling or licensing. And therefore, it is very important to have a legal right over that particular product. And therefore, registering IP, maximum IP means you can have patent, we can have an industrial design, we can have a trademark, and then we can have a bundle of rights. And that bundle of rights, you can have that negotiation while you are selling or licensing that particular. You will have a positive image when you have that portfolio, because with that one product, you have a portfolio building, just like a wealth portfolio, you are building an IP portfolio, and that IP portfolio definitely helps you in the negotiation, and it is a reward for the creativity, the efforts, because design, when you are doing it, is many times it is like a lot of version comes, and maybe 10th version, 12th version, you are successful, and then that product comes into the market. So a lot of efforts goes into that, and design, that protection is a reward for the creativity. Now, what is the status of India considering the registration of this? You can just see that if we consider the data, in 2019, 76,000 industrial designs were there. And now if you see in 2024 data shows that there is like 1,41,000 designs are in force at present in India. And you can just see the filed, the designs and then the registered designs. And in 2023-24, we can see that 30,000 designs are registered filed, and 30,000 plus, like 30,670 designs are registered. Considering the origin, if you see, India and foreign, because that due to the TRIPS agreement, obviously, and we are a Paris Convention that member, Paris Convention member we are. So obviously, the other country residents can register design in India, and they will have a national treatment as if they are nationals of India. And you can see that if I focus on 2023-24 data, India registration, that Indian resident have registered 26,000 patent, 26,000 plus industrial designs, and foreign like 3,000 plus registrations are there. If we see the registrations like that state-wise, we can say Maharashtra is in a top position, and then Tamil Nadu, Delhi, Gujarat, and very surprisingly, you can see that obviously Jammu and Kashmir is also there in design registration in that top 20 in 2023-24. Moving further, if you see this India map, you can just check again that the number that each state-wise and union territory-wise registration, and we can say that yes, awareness is there, and state-wise we can say there is a registration, industrial design registration is there. If we see country-wise, you can just see that USA is a topmost considering registration in India, because they want to use obviously market in India. So USA is in a top, then Germany, China, Japan, Korea, you can just see the list. They are like companies which are there or individuals they are there, they are registering their designs in India, and USA is in the top. If we see the top, we can say the applicants considering 2023-24 data. Sabyasachi Kolkata alone in 1 year filed 1,067 industrial design registration, and then the list is there, you can just check that. Then if you see foreign filers, then you can just check that Samsung, Philips, Skechers, right? They are now, you can just see Porsche is there, and then they are registering their designs in India. When we see the filed exam registered or disposed number, as we have just seen, 30,000 plus industrial designs are registered, and 29,000 plus like examined, and 30,000 plus is registered designs. Disposal is there because sometimes it is abandoned, sometimes it is not, like a FER is issued, but applicant have not responded to that, and at that case that applications were disposed. Now, if you see there is a Locarno classification. If you see any of the IP, some classification we are following always. For example, for trademark we are following this or nice, whatever pronunciation you want to do, that classification we follow. If we see this patent, we have international patent classification. So similarly, when we see industrial design, we follow Locarno classification. Now, why this slide is important, that we can just check that class 2, class 12, class 24, class 15 and class 11 are the top classes where Indian applicants are filing the registration. So it gives us idea that, okay, which class is like focused by most of the creators, and how definitely if these are the classes, we can say that yes, market is ready for such kind of products, and we can think about the development of products or having such kind of products into the market with the industrial design registration. And you can just see for this class 2 is for clothing, or class 12 is for transportation, class 24 is medical and lab equipment. So we can have that details here. Now, if you see for the foreign applicants, we have seen 3,000 plus applications are there by foreign filers, so or foreign residents. So where they are focusing on? They are focusing on class 24, medical lab equipments, right? Then there is a class 12, transportation. Class 14 is there for recording, communication or information retrieval equipments is there. There is a 23, which is related to sanitary, that equipments, distribution equipment, sanitary, heating, ventilation, or you can just check that class 9, which is related to containers for the transport or handling the goods is there. When we see the revenue generation from this intellectual property alone, we can see Kolkata because head office of industrial design for industrial design is Kolkata. So there are 4 offices where you can file your industrial design registration, like Mumbai, then Delhi, Chennai, and Kolkata. The examination happens in Kolkata office, and we can see that it is almost like 9 crore plus, like the revenue is generated only from industrial designs. This is the site where if you want to go through the records which are there, which are like registered designs, you can just go through the website of IP India and you can just look into the various designs which are registered there on this. The key features, what are the key features of design? We can say that it is a relatively inexpensive form of IP, definitely. It is a very easy form. Just now, sir has shared that, okay, 6 views. We have to just take photographs or that particular, on trace paper, you can have that particular design. And then along with that, some documentation is there, some details we have to give. So it is so easy. No drafting, nothing is like that. Like in patent, we have a lot of like efforts we have to take for drafting, and then claim drafting is especially a very, we can say, important part when we are talking about patent. But considering this industrial design, it is a very easy to file, and anybody without help of, I just insist that without help of attorney, without help of any expert, IP expert, can do it easily. If you go through the website very nicely, CGPDDM office website, if we go nicely, they have given the checklist and everything is online. Only if you have a digital signature, you can do sitting registration of industrial design very easily if you have a system and a digital that signature. That's it. It's very simple actually. So novelty aspect is very important, that what exactly that novel thing is there. For example, I can just check that the example of cooker, solar cooker had shared, that he has shared that how exactly the novelty aspect is there, along with the patent, industrial design, and how exactly that design, what efforts they have put to bring that particular product into market. That novelty aspect, considering design, will be important when we are doing the industrial design registration. Okay, but we have to remember, I have highlighted that it is a very weak form of IP. Now, why? Because a small tweak in that shape, that easily somebody can do, and they can have a next version, and they can file that industrial design registration for that. And therefore, it is it is very wise, like along with design, patent, trademark, trade secret, okay, all these other IPs we have to take into consideration. So novelty is crucial. It is a statutory right. So you can go into district court, you can go into that court system, and you can have that remedy, considering that if any infringement happens. Okay, so there is no requirement of inventive step, because inventive step is a function of a patent. Okay, so only aesthetic aspect is a very important when we are talking about a design. If we go into the details, statutory details, this is the definition of design. Probably you might be knowing, but I will just focus on features of shape, configuration, pattern, ornament or composition of lines or colors. That is very important. That is the external appearance. And another word which is highlighted is a article. Now this is very, very important. I will share one judgment actually quickly related to Apple and Samsung. So what that article is important, because when industrial design, when we are talking, it should be independable, sellable article. So for example, if I take a car, in that car, that one, like a screw also is an article, that we have to remember. That is very important actually, okay? And two-dimensional, three-dimensional, both forms are like a, like you can go for a registration of that. And every time I'm like emphasizing appeal to and are judged solely by eye. That is very, very important. Other things you can go through, okay? So what is to be established when we are talking about examination, when we're talking about any infringement case? Novel feature is very important. Visible to eye is very important, and article, independent article is very, very important. Considering the time limit, I will just skip quickly. And considering the good form of protection, we can say that customer base is very important. You have to think about customer always when we are designing that particular product, okay? Now, when we are talking about design, it should not include, what it should not include? It should not include mode or principle of construction, because that is a function of patent, which is a mere mechanical design. That is not kind of acceptable. Purely functional features, again, it is a work of patent. And the trademark, like sunrise, the name which is given, it is a trademark. So that will not come into the design protection. Okay, what we have to remember, that if you want to renew that 10th year, you have to remember that I have to renew it. Otherwise, it will go into the public domain. Okay. Now, just see this Apple and Samsung and the judgment. You can just read that. What point I want to emphasize here is like that. This fight between Apple and Samsung was very well known. They were fighting for that. There were almost 50 plus cases. They were fighting for $1 billion actually, considering design and obviously other aspects of IPs were there. We have to remember that this fight, if you go into the US, there is a design patent and there is no industrial design registration. So that fight is over the design patent infringement actually. Okay, and here important part is that article of manufacture, and it is very good clarified that, okay, you are buying mobile, but the components which are present in the mobile that are important, like independently sellable, maybe consumer is not buying that separately, but that is buying with that whole as a mobile. But we have to take into consideration each and every aspect of that article and the features when we are talking about the industrial design registration, okay? Because their fight was related to like that internals, that components, and that internal components are independently sellable. So that is a matter which is like as per definition, article is coming into the picture. And obviously they can, that court have given the ruling that yes, the article which are there inside that product, like maybe it may be a car, it may be a laptop, it may be a mobile, that is also have that industrial design protection. Okay, and if you can see that series of patent infringement suits were there, and that were like related to smartphones, like a phone war was there actually, and it is still there. Telecommunication industry, you go, phone war is still there, and I have just highlighted the companies. Lot of cases are going on related to industrial design protection actually. And if you see particularly Apple and Samsung, I have just mentioned that their cases, if you see the ruling, Apple one ruling in USA and Samsung one ruling in South Korea, Japan, and United Kingdom. And you can just see iPhone 3GS and then the i9000 Galaxies. They have that lot many kind of cases going. Now it's very interesting case. I will just quickly share here. Can you just gauge who are they? I'll take more, just 5 minutes, and I will try to wind up. Can you just gauge who are they? You can just write down in the chat box if possible. Let me see if I can check the chat box. Here, if you see, I just give you hint. Everybody know this, right? Barbie doll. And here is the story. You can just see Barbie born, we can say, in 1959, and you can see the evolution till 2015 here. Now, if you see, Barbie is almost 65 years old. Okay, but she is not aging, right? So when we are talking about Barbie, it is a very classic example of a IP management. Now, you just see here, the picture which I have shown, it is of Ruth Handler and Elliot. that is it is a discovery, or it is, we can say, the invention. When they were he was like with a daughter and with playing with the dolls. At that time, Ruth has created that particular doll, and you can just see the modifications. And Metal Toys, it is a very big company. Every time I am going to do the search report for industrial design, Metal Toys always come. Actually, they have a lot of products which are like protected using industrial design as a IP. And this Metal Toys, you can see how strategically they have marketed this particular Barbie. You can see that they have extended Barbies, that doll with the family and friends. So you can just see Barbie have a sisters, Barbie have friends, Barbie have a boyfriend, and Barbie have her own house. And you can just see here in California, human scale dream house is created for a Barbie, and how they are doing the marketing of that one industrial design protection. Then they have another different types of IPs, effective brand building, effective marketing, and a successful, we can say, case of IP management. Here is a car of Barbie. You can just check. And yes, what they have announced that in 2023, that Barbie owner Mattel plans 45 more toy movies as IP and nostalgia trend continues. So see how effectively they are using. This is a very classic case of marketing or building the brand and IP effectively. Okay, so you can just see that Barbie gets at least 100 new clothings every year. And therefore, because of this, Mattel become the biggest garment manufacturer in the world. I have just told you that Barbie is having a lot many other relationships, and she represents nearly 100 different nationalities. There are first, we can say, ponytail Barbie, it was sold in for $3, and you can just see Barbie cost now maybe up to $30,000. What an effective brand building, actually. And the path was not easy. Barbie has gone through a lot of legal cases related to industrial that design also, and other types of IPs also. They have faced big backlash in Saudi Arabia and that kind of countries because of that look which they have presented, or they have brought the Barbie into the market with a different outlook. And that is a very interesting case, actually. So path was not easy, but we can see here the effective brand building and the effective use of industrial design. I will just keep these examples, and I would like to come to the that last, that is a strategic part, considering the IP management when we are talking about industrial design. I will skip this case law also, but what we have to focus on when we are talking about this industrial design with we have to think about other IPs and IP strategy. This is very important when we are talking about design commercialization. Generating idea, a lot of ideas are created. Even the inaugural session yesterday, it is shared by Dr. Jere that see that there is a whole lot of idea bank is created through various hackathons, actually. So we are rich now with the ideas, right? Now, how we are going to reduce these ideas into the tangible form, right? That is very important. So probably we have to now think about how we are going further, from that idea to the market. That is very, very important, actually. Effective IP strategy, Barbie case is a very, very important, how effectively they have used IP strategy. Technology transfer is again very, very important. Sir has just now shared that, yes, if MSME is there, 50,000 is good enough, because probably their capacity is that much only. But I say that MSMEs are very promising. They are doing that particular task for many years. And probably if you have a non-exclusive licensing, probably that is a very good way to expand the market. Because when we gave it to 1,000 MSMEs, probably that will be you can just imagine if you give 1,000 MSMEs with a 50,000, good revenue generation is there. And that is a very good strategy, actually, because observation is like this. If we go into the big player, probably we may not stand in the negotiation. That is my experience actually with the patent also, with the industrial design also. We are like a very small fish, we can say, in the, and the big players are a big fish, and in this market, probably we may not stand, we may not negotiate effectively, but probably MSMEs is a very good example where we can negotiate and we can have a non-exclusive licensing. Probably that is a very good way of licensing or selling of the product. Design commercialization, when we are talking, product development and business growth. Product development, other types of IPs will come. Business growth, marketing aspect we have to take into consideration. And key stakeholders, as we have just seen, that designers, marketers, manufacturers, creators, okay, all these engineers obviously will be there. So if we see the stages of that commercialization, obviously idea generation is there, designing and prototyping, and it goes into the various stages. Market research and validation is there, then manufacturing and sourcing is there, sales is there, and post-launch evaluation is there. Lastly, a few questions we should ponder on. Whether single IP design will be sufficient? Only one type of IP is sufficient? I will say no, definitely not. You just think about it. Whether other important factors along with IP are important? Yes, definitely. We have to think about other factors. We cannot just say, oh, I have my design registration, I have received that design registration, and now there will be a queue for asking the that my IP, and there will be queues, people will come. That will never happen. We have to take efforts. We have to think about other IPs. We have to think about obviously the marketing of the lot of efforts are required. Whether Indian toys can grow like metal, like Barbie case, just we have to think. I will just share the example, the few examples here. And whether India origin articles can be strategically used, business development around specific geographical indicators. Here is an example. Now you just see the Channapatna toys and dolls, or Kondapalli Bombalu. These are we have registered GI on it. Whether we have a successful in marketing of that. Just think about, like a metal, Barbie cases like that. Barbie have a sisters, a family, and then the aligned products are there. Can we think about such kind of a thing around this particular toys? Because this is like our GI registered. We can have industrial design registration also with some modifications. Obviously, novelty feature and all this thing we have to take into consideration. Just think about it. We have to think about a trademark around that, whether that is possible, whether other products, aligned products are possible to develop this particularly like a Barbie. These are our GI registered products. The articles are there, very specific to India. Can we think about something that jewelry designs are there, or this mirrors are there, some articles that Bidri wear is there? Can we think about the other types of IPs, and we can build a portfolio, bundle of rights, and then can we do the marketing of that effectively? Here are some few more products are there. So the point is like that, we have to think about this particular questions, so that we are creating, but along with these questions, that along with the creation, whether we have taken efforts for the commercialization. And Barbie case, I always feel, is a very good example for a life sustainability. We can say that development is there, and they are leader in that particular domain, we can say.